so everyone, a jury's going to be upstairs at 10:30. So everyone who's here now, you have the court's permission to step outside in the hallway and call your attorney if you don't see them. If your attorney does not appear by 10:30, what's going to end up happening is you're going to be called back. So you can get your business completed today, it's probably best for you to step outside and call your attorney. Denny Callahan, who did you want to speak to me about?
Mr. Conrad, I believe, was sick yesterday,
Okay.
but he was not here. He was in his probation office.
Mhm.
And I instructed him to bring the restitution information that the insurance that he had on his car, he believes was already paid to the complainant. And the hearing that was set yesterday or today is the question of how much restitution, if any. That question is going to be answered as soon as the probation gets the papers.
Could I see the file on Randy Tamez, please?
The DWI was a car crash.
Okay. All right, state on this, do you have an update on restitution?
I do not.
All right, so when are you all gonna have an update on restitution?
I don't know.
All right, so this is what we're gonna do. We're gonna recall this case. There will be no more restitution hearings. If the court doesn't receive a restitution amount, what's gonna end up happening is the amount's gonna be zero.
I
And we will
understand.
not have another restitution hearing. So council, we'll recall this back on May 27th.
You need the defendant present,
He can appear by Zoom.
right? 27. Hey,
Yes.
Thank you.
All right. Ms. Ferguson, Tamez is going to be May 27th for restitution hearing. Could I see the file on Israel Moscata? All right, state. Are you all aware of the issues with Mr. Mancata?
This was just a prior motion, use this.
Yes.
Okay, yes, so this was just follow up to see where he was in that process stretch.
All right, Mr. Mancata, can you unmute?
Yes, Your Honor.
All right, and is your attorney on with you?
I believe not. I haven't seen him or spoke to him.
All right, and who's your attorney?
George Schaefer.
Okay. All right, so this is to get an update on your driver's license.
Yes, Your Honor.
So do you have it or not?
I had an appointment a month ago. I went and I told her it was suspended till June 3rd. So she gave me an appointment for the 29th. And she told me to do my driver's course, which I have with me. I made a copy of my certificate, if you could see.
Yes.
I'm not sure if you see it. Okay,
Yes,
yes.
I can see it.
So yes, I go on the 29th and I'm pretty more than sure I'm gonna get my driver's license on that day.
All right, so this is what we'll do. We'll have you, and you can zoom back in. We'll have you zoom back in on June 3rd. And if you do have your driver's license before then, just make sure if you give a copy to probation or let probation know and provide them the documentation, you won't have to come on June 3rd.
Okay, sounds great.
Probation, is there anything else? All right, thank you, Mr. Mancata. Have a great day, and thank you for dressing appropriately for court, even though you're on Zoom.
Yes, ma'am, of course. I appreciate you very much.
All right, thank you.
Thank you.
All right, Mr. Dominguez, who do you have?
Good morning, Your Honor. I am here on Mr. Tyler Ketchum.
All right, he's
And I
not
believe you
here.
had a, aside from that, Your Honor, I do have a motion to withdraw before the court on this issue.
All right, so he's not present. A warrant's going to be issued for his arrest. And as soon as he's taken into custody, we can hear your motion to withdraw.
Understood, Your Honor.
All right, thank you.
With that, may I be excused?
Yes, you may be excused.
Thank you, Judge.
You're welcome.
Oh, there is Smollett. I'm
All
sorry.
right, hi, Mr. Millett, come forward, please. All right, Mr. Millett, your attorney's not here today. They're in Del Rio. Have you had any contact with your attorney?
No,
Have you ever spoken to your attorney?
no.
Do you want to keep that attorney or would you like a new attorney?
I would like a new attorney, please.
All right, just have a seat. We'll make sure that you receive a new attorney, okay?
They can share this house.
Mr. Martinez?
Yes, ma'am.
All right, so you were sent to felony drug court. Yes,
Yes, ma'am.
This was an active participant in felony drug certification. And he was transferred back to regular caseload due to his physical limitation.
okay.
So is that it?
You can have a seat.
Please. Time, quick.
So probation, what do you recommend?
I recommend with all of the previous conditions of probation that was mandated.
All right, what was the TAP recommendation?
Indicates to evaluate her PDRF.
All right, do we,
Qualified for PDRF is sort of evaluate for status judge. Does have medical does have some medical issues, Judge.
all right, so I don't know if the issue here is DVRF, it's more drugs. Am I correct? Isn't it more alcohol and drug use?
I believe alcohol for sure.
Mhm.
And since he was in felony drug court, the drugs as well.
All right, Mr. Martinez,
Yes, ma'am.
are you on any type of medication for mental health?
No, ma'am, my doctor let me go. My psychiatrist let me go for I missed 4 times. Some years back, well, cause I went to Prunia. I showed him the paper, but the secretary knows. So he fired me. After 4 times I missed because I was Prunia.
All right, do you have a case manager?
Case manager,
Yes,
for what?
with regards to your mental health. Did they assign you a case manager to help you?
What case manager, where?
Well, a case manager, there's usually one assigned when people have mental health issues. The case manager is to help you, one, stay on your medications, make sure that you make your doctor's appointments. And if you
Yes.
don't make your doctor's appointments, then they usually will come out to your home or call you and try to figure out what the issue is and why you're not making your medical or mental health appointments. So do you have someone like that, a case manager? And it's usually a professional person. I don't mean,
Sister,
I don't mean your sister, but I mean, it's usually someone else. Is your sister here in court?
yes, ma'am.
All right, everyone, just give me a moment, please. All right, if his sister can come up, please. Who is your sister here?
Yeah, she's coming, Judge. I just talked to her just a little bit.
Okay. Hi. All right, so I'm trying to make sure he stays on track and that he doesn't end up getting arrested or anything. So do you know, does he have a case manager?
Oh, actually not yet, but
Okay,
I was talking to him about it, that he was gonna need one,
okay.
because I've been helping him so far since he's been out of, since he's been out in probation, I think.
Mhm.
So, sooner or later, he's gonna have to get one.
And when you say you're helping him, and when Judge Boyd is talking about a case manager, she's talking about mental health counseling, but you're probably talking about physical, correct?
Yes.
All right, so he told us that he was fired or let go from his mental health treatment because he had missed some appointments.
Oh,
Okay. All right, so I think what we need to do you think you can get in touch with the people from behavioral health? And we can do. They-
So Judge, what I suggest we do is, get him a referral to Center for Healthcare Services.
Okay,
And I think we should gather a little bit more information on what's going on with his health.
mhm,
He does not, one of the conditions of his probation is for him to have an ignition interlock. He does not drive, he doesn't have a vehicle or anything. Just spoke to his sister about that. Have you been drinking?
No, man.
I think we should probably go forward with getting a portable device
mhm.
and see what the medical records are saying for any other limitations so that we have a better idea.
And do we need an updated tap or no?
The TAP was just completed not too long ago, Judge.
All right,
That's what's concerning.
mhm.
The file looks a little weird, to be
Oh.
quite honest.
All right, so this is what we're gonna do. I'll go along with you, probation, refer him to Center for Healthcare Services to see if we can figure out what's going on with his mental health. And then he'll need to do a medical release to probation so we can figure out what's going on physically with him as well. And then I'm gonna want an affidavit of non-driving and non-ownership of a vehicle. And then we'll do the portable device. And then I'll set this for a return for an update so we can see what's going on. When do you suggest?
30 days, Judge.
All right, so we'll come back on. Let's make it June 24th.
Okay, Judge.
All right, so we'll be back on June 24th. So on June 24th, they'll be able to tell me more how to address drug issues if you still have drug issues, okay?
Yes, ma'am.
But what I'm gonna need you to do is, you're gonna have to do a medical release so that probation can know what's going on with your mental health issues and also your physical health, okay?
I have to pay another psychiatrist because I've been looking for one.
Oh, they're gonna refer you to, you're gonna receive a referral to Center for Healthcare Services,
Oh, good.
okay? And so, and we'll come back on June 24th.
Judge, how long are you gonna give him to obtain the portable device?
All right, you're gonna need to have the portable device by June 3rd.
And third,
Yes.
June the first is my birthday.
Huh?
June the first is my birthday.
All right, well, happy soon to be birth month. All right, once you sign the reset form and speak with probation, you're excused. All right, thank you.
Judge.
You're welcome. Mhm.
So when that has a pending felony in your court and a pending misdemeanor, we have reached an agreement on the misdemeanor only with the TIC on the felony in Carlo Key's court. Think that you're likely to send the case to Carlo Key.
All right, so you're saying are they planning on reducing it to a misdemeanor or they,
Two separate cases. Unlawfully carrying misdemeanor, drugs in school, felony.
all right, so, and I'm sorry, what is happening again?
TIC felony plea to 2 years deferred adjudication on the pistol in misdemeanor court.
All right, do you know when you'll be able to do the plea on the misdemeanor?
I don't know that, but soon I suspect.
All right,
Yeah, I wasn't sure if they would accommodate today because I think he's in custody. So
All right, let's see, are you available if they can accommodate today?
Yes, Your Honor.
All right, Ms. Ferguson. Can you contact Judge Key's court to see if they could take up Tyler Millet's case?
And just so you know, the misdemeanor is still unfiled, but the evidence.
Jeremiah Simmons? All right, state, are you aware of the defendant's motion for continuance?
Yes, Judge, I have reviewed it. I'm not objecting to it, given what's in the motion, but I just want it notated that the state is ready for trial today.
All right, we'll go on the record. Court is calling 2000.
record, part of the courtroom.
Thank you. Court is calling 2024 CR 008-134 State versus Jeremiah Simmons. Can I have parties announced for the record? State,
Megan Galloway for the state.
defense,
Martin Guerra for Jeremiah Simmons.
and are you Mr. Simmons?
Yes, ma'am.
All right, this is scheduled for trial today. Your attorney has asked for a continuance. Off the record, the state has stated you're ready for trial.
The state is ready, Your Honor.
Are you in agreement with the motion for continuance for the defense, though?
I'm not objecting to the motion, Your Honor.
All right, you may be excused.
Thank you.
All right. Mr. Simmons, you understand the reason for your attorney's request for a continuance,
Yes, ma'am.
and you have no objections?
No, ma'am.
All right. If y'all will, the court will grant your motion if you'll confer with Ms. Ferguson on a new jury trial date.
Thank you, Judge.
You're welcome. And Martin, everything is gonna go fine.
Okay, thank you, Judge.
Yeah, it will.
She's a little nervous.
Tell her don't be nervous. It's gonna be fine. Luis Espinoza. Yes. And where's Mr. Espinoza? All right, Mr. Espinoza, come on down.
Judge, apparently I was appointed on this gentleman when I was out,
Okay,
okay? I didn't know anything about him when I got back.
okay.
I didn't get a notice of today's setting.
Mhm.
Just with court's acknowledgement. I ran a week-long search this morning on my settings because you're aware in the courthouse that people aren't getting prison or
Mhm.
jail things. So he didn't even come up then.
Okay.
I don't have discovery on him.
Mhm.
I hadn't visited him, didn't know his name. I actually came in this morning to make fun of Norma because she told me I needed to be here before 10:30 and that blew up in my face. So just to let you know, that's where it was.
Mhm.
I'm asking you to recall it for a week. Let me get the discovery. The state needs to get his history to make an offer. I have conferred with them. I've been talking to him now, but I'm at a blank.
Okay.
So we're gonna have to recall it next week if that's possible.
All right, Ms. Ferguson on Espinoza recall for May 29th. Is that enough time, counsel?
I think so.
Okay.
Like, I know his name. I
All
introduced
right.
myself, but that's about where we are right now.
All right.
So, thank you,
All
Judge.
right, thank you. So Mr. Espinoza is gonna come, you're gonna come back on the 29th, sir. All right, thank you. Who's here on Josephine Marquin?
Morning.
Good morning.
How are you doing?
I'm doing fine.
Judge, I've conferred with the state this morning and I have made an offer. There's some discovery that I've asked for their assistance in obtaining that my client has told me about. I'm also going to be filing a motion for an investigator so that I can do my due diligence trying to obtain that information. So we're just asking for one more discovery reset.
Right.
Mr. Garrigan didn't have an objection. He's been very helpful, actually. He's gonna,
All right.
Look at that.
Mhm.
well, he already sent the email to ask for the information I need, but I'm just gonna cover all my bases.
All right, I'm putting your plea deadline date at July 8th,
That sounds good. Thank you. That'll give me time.
and you need to make sure you're on time for court next time, you
Yes.
understand?
I've been in time, I was in time, Judge.
No,
Or
you were
told me-
not. You
Oh,
came in
really?
late.
You know what? I had to go report in the bond. They called me last night and they were gonna issue a warrant, so I went over there and then I made it back, but it was a long one. Thank you, Judge. I really appreciate it.
All right. You're welcome.
will
Once you
be.
sign the reset form, you're excused.
Yes, ma'am.
Thank you.
Thank you, ma'am.
You're welcome. Alejandro Nuncio. And probation, there are no applications. All right, the court is calling 2025 CR 002305. State versus Alejandro Nucio. Could I have the parties announce?
Jason Garahan for the state, Your Honor.
Danielle Cranberg for the defense.
And are you Mr. Nuncio?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Nuncio, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Nuncio, did you review the admonishments with your attorney?
Yes,
Did
ma'am.
you understand it and sign it in all the appropriate places?
Ma'am.
Did you understand you're charged with theft of property less than $2,500 with 2 or more previous convictions?
Ma'am.
That's a state jail felony?
Ma'am.
Just 1 second, sorry. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Nuncio, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the state jail facility. There's $1,000 fine and no applications. Did you understand those were, that to be the plea?
Yes, ma'am.
State,
Yes, Your Honor.
defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all attachments.
No objection, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court to follow the agreement, Your Honor.
All right, Mr. Nuncio, why do you continue to steal? What's going on in your life?
I'm just choosing path in this
Let me ask you this. How old are you?
33.
All right. Do you want to spend the rest of your life in and out of prison?
No, no.
So you're gonna have to make some changes. If the issue is you don't have money for food or you don't have money for things, then you're gonna have to get a job.
Yes, ma'am.
However, if there are drug issues that are going on with you or mental health issues, there is free help for you. You understand? When you're released from custody, if I'm still here and you can't find a place, if you come back here, I'll pick up the phone call to get you some help, okay?
Yes, ma'am.
All right, the court is finding you guilty. The court will sentence you to 6 months in the state jail facility. Give you credit for any time served. There's $1,000 fine, time and money to run concurrent. I'll request the therapeutic community. And there's to be no contact with Walgreens.
Yes, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck with you, to you, okay?
Yes, ma'am.
Thank you, Judge. Thank you. Who's here for Matthew Insuriaga? Where's Mr. Insuriaga?
Thank you, Judge.
All right, so the last time we were here, he may have had a new case.
Yes, Judge. So the last time that we were here, I reached out. The new case, it's sealed family violence case. I reached out to the intake prosecutor, and she is in receipt of the file, but not all of the evidence yet. She has been reaching out to the detective and has been collecting the evidence, but is still not ready to be presented to the grand jury. So I've conferred with Mr. Woodard, but I guess I would just be requesting a little bit more time for her to get the case indicted. That way we could make a global offer to the defendant.
All right, what we'll do then is we'll come back on June 24th. Is that a good date for you?
That's fine, Judge.
All right, once you sign the reset form, you excuse. Thank you for dressing appropriately for court. Thank you. Adam Quintana. And probation, there's no application.
Judge, there is a oral amendment to the.
Okay.
It's
this-
it's just a call,
Okay, I'm like, is it a complaint?
not a complaint.
All right.
I just want a fair one.
All right, thank you. Court is calling 2025 CR 002278. State versus Adam Hernandez Quintana. Can I have parties announce?
Jason Garahan for the state, Your Honor.
Roberto Ambrosino for the defense.
And are you Mr. Quintana?
Sean.
Counsel, have you received all discovery?
I have,
Did you review it with your client?
we did.
Court will find that the state is in compliance with discovery. Mr. Quintana, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We did.
State, are you proceeding on the indictment as presented?
Well, there's an oral amendment, Your Honor,
Yes.
and it is in the second to last line at the end of that line, where it reads cause number 2022 CR 084. That should read 2022 CR 0824, adding the two.
Any
No
objections? Do you have any objections to that amendment? All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Do you understand you're charged with theft of property less than $2,500 with 2 or more convictions as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yeah,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Quintana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with his attorney? Did you understand it? According to the plea, punishment is to be assessed at 180 days in the state jail facility. There's a $1,500 fine and no applications. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Sir,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor, state exhibit number 1 with all of its attachments.
no objection.
State you may be excused.
Thank you, Chief.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, so the court will review the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Why are you continuing to steal? What's going on?
I'm in the street, I was in the streets, I've been in the street for a minute.
Yeah.
It's getting harder out there.
Well, here's the thing. Whenever you can't use it as I need something and use it as an excuse to steal, because guess what? You're going to be in and out of prison, in and out of jail. How old are you? 37. And the reason why you're in felony court is because you've stolen at least 2 times before. And now I've read in the reports, the item you stole was $3.13. And now you're going to prison, well, state jail facility for 180 days over $3.13. That's pennies per day, and you're giving your life away for that. All right, this is what the court is going to do. The court is going to sentence you to 180 days in the state jail facility, give you credit for any time served. I'll request the therapeutic community. If there's a drug issue or something else that's going on with you, therapeutic community will address that, okay? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. You understand? All right, we can go off the record. Here's the thing. If you keep picking up theft cases, it's going to be more state jail felonies. And at some point in Texas, those state jail felonies become habitual, and you're looking at a 20-year sentence. You understand? All right. Oh, and Deputy Laura, Millette needs to go to county court at law number 5 with Judge Key.
5 or 14, Judge?
Oh, whichever Key. Is he in 5 or 14? 14. All right, thanks. All right, so do better. When you get released from custody, if you can't find a place to help you with your drug addiction, if you have one, or housing or something like that, if I'm still here, come back here and I'll pick up the phone and call somebody to help you, okay? All right, good luck to you.
Thank you.
You're welcome.
Thank you.
All right, who's here on Christopher Pena?
I am, Your Honor. Eric Wilson is here. Come on up.
Okay, on this case, where are we on discovery?
Your Honor, this is a very first setting. I came in to talk to defense counsel. I've downloaded Discovery and they've offered me a pretrial diversion. We'd like to put in an application for that if possible.
All right. Ms. Ferguson, I need a reset date for PTD. Right. All right, we'll see you all back here on June 17th. Of course, if they dismiss it before then you won't have to appear.
Thank you very much, Your
All
Honor.
right, thank you. Thank you for dressing appropriately for court.
Thank you, ma'am.
You're welcome. Once he signs the reset form, he's excused. All right, who's here on Patrick Washington?
Washington, we're pulling that back for now, Judge.
Okay.
We're going to continue to confer about that matter.
All right, Mr. Washington, if you'll have a seat, please. Hello. Hi, Mr. Grant.
Hello.
All right, so you've had a chance to meet your attorney? Okay. And what's the update, Mr. Callahan?
Well, able to reach an agreement. We asked for a felony last date
Okay,
reset, give him time perhaps to think, reevaluate.
all right, sir, how old are you?
55.
All right, so I'm gonna give you a plea deadline date. Council, does June 5th work for you?
Yes, Your Honor.
All right, so you need to be back here on June 5th. At that time, you need to let the court know whether or not you've reached an agreement. If you have not, Your next setting is going to be a jury trial date. Do you understand? All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
Thank you. No. Deputy Laura? On Alfaro? We're gonna recall that, state on Jonathan Alfaro. There was an agreed incompetency. So we're gonna recall that for, I'm gonna say July 28th, just so we'll see where he is.
Okay, Judge, yeah, because
I'm sorry.
I think he's scheduled for something on May 27th or something well, I was about to say Brothers Court.
Okay, well, just one second.
That's what I saw on Odyssey, but because the only reason is I talked to Cornelius yesterday.
Okay, so do you, and you say he's scheduled for what?
He's scheduled for something, that's what it said in Odyssey, so I don't know if it's accurate, but I know it was like for the
Oh,
27th.
okay. He's already been reviewed for sanity, which tells me that he was previously competent. This is odd,
Yeah, it's
because usually you can't do sanity until someone is deemed to be competent. And now, all right, this is what we'll do. We're gonna recall this for June 16th.
Okay.
So we can see where we are with regards to his mental health.
okay, Judge.
All
Thank
right,
you.
thanks. Norma, on Alfaro, we're gonna recall it for June 16th. Yes, because from this, it appears that they already did a sanity evaluation, but then they had an agreed incompetency hearing. So we'll put it on June 16th.
Your Honor, if I may,
Yes.
I just did an appeal where they did that same thing. I don't know if that's correct or not, but they did the insanity and the competency at the same time.
Well, I mean, legally, I'm sure what they're doing, I'm sure what they're doing is they're doing the competency first, and then if they're found competent or they think they're competent, then they go to the
It
Senate.
just looked like they were within a couple of days of each other, Judge.
Okay, well, that's efficient. So, yeah.
I just know that happened, Judge. I'm just letting you know.
All right, thank you. All right, who's here on Luis Alec Martinez?
Joseph Stateson, we're ready, Your Honor.
All right, where is he?
Judge.
Good morning.
Morning, Your Honor.
Good morning. Let me just find him on the docket. All right, so audio, video, any of that exists?
Judge, so I reached out to the arresting agency and he informed me that there's no additional videos or audios associated with the case.
Okay. Anything else with discovery?
Not for discovery, aside from I've asked the state to contact the CW. I know that they have recent contact with some. I've asked if they can reach out to the others. And I've also proposed something that would potentially resolve the case with some upfront restitution. Megan and I discussed a number. My client's going to try to gather some funds. He would need some time to gather funds.
All right, your plea deadline date on this case is going to be June 26th.
June 26th.
Yes, once you sign the reset form, you're excused. Thank you for dressing appropriately for court. All right, is there anything else?
Nothing further at this time.
All right, thank you. Who's here on Aldo Sandoval? Cindy, are you okay to go forward? Yeah, you can go. All right, court is calling 2025 CR 002368 State versus Aldo Sandoval. Could I have parties announced? It's criminal trial division.
I'm sorry, Judge.
That's okay.
Megan Galloway for the state.
Renee Munoz for Mr. Sandoval.
And are you Mr. Sandoval?
Yes, yes.
Oh, and state, I know you are conferring on other things. If you need to answer from there, that's fine.
Okay, thank you.
I'll take care.
All right, for the state.
Andrew Harrison.
All right, counsel. We have an interpreter, is that correct?
Yes, Your Honor.
All right, if I could have the interpreter, if you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand. Mr. Sandoval, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
Counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to explain these documents to your client in Spanish?
I was, Your Honor, yes.
Counsel, have you received all the discovery? Did you review it with your client?
That is correct, Your Honor, yes.
Court will find that the state is in compliance with discovery. Mr. Sandoval, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Sandoval, did you review the admonishments with your attorney? Did you understand it?
Yes.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Off the record, counsel, no speaking behind the court reporter. If you want to speak to your client, just ask the deputy to move them to the other end. All right, we're back on the record. Court does not have to follow any plea bargain agreements that you've reached with the state. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, yes, yes.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, that is correct.
Mr. Sandoval, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, it's fine. It's
Has
fine.
anyone promised you anything other than the plea?
No, it's fine.
No, my question is, has anyone promised you anything other than the plea bargain agreement you've reached?
No, it's fine.
I'm not asking you if it's fine or not.
No.
Has anyone promised you anything other than the plea bargain agreement that you've reached with the state?
No, it's fine.
I may have a moment just to clarify.
All right, Mr. Sandoval, do you understand what's going on?
Yes.
All right, so you've entered into a plea bargain agreement with the state. Do you understand that?
Yes, I do understand.
All right, other than whatever plea bargain agreement you've reached with the state, has anyone promised you anything?
No, it's fine this way.
All right, the plea bargain agreement you've reached with the state is 128 days in the Bexar County Jail. Do you understand that?
Yes.
Has anyone promised you anything other than 128 days in the Bexar County Jail?
No.
Are you satisfied with the way you've been represented?
Yes, I'm fine.
Are you a US citizen?
No, from Mexico.
Counsel, you want to address the immigration issues?
If I may, Your Honor.
Yes.
With regard to my client's citizenship, he is in fact a Mexican national. I have contacted an immigration attorney and he has met with my client. Working in conjunction with him, we were able to speak with my client about potential consequences of a guilty plea and a felony conviction. Knowing the consequences of this plea, my client wishes to move forward with it so he can be under the custody of the immigration authorities to see how they wish to deal with his immigration case.
All right,
Yes.
do you understand, with the conviction, a felony conviction for a drug case, you are gonna be deported? Do you understand?
Yes, yes.
Have you had a chance to speak with an immigration attorney?
Yes.
All right, and you understand that you will be denied naturalization? That's yes or no?
Yes.
The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did understand it.
According to the plea bargaining agreement, punishment is the assessed at 128 days in the Bear County Jail under 1244. Did you understand that to be the plea?
Yes, I did understand.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, yes.
Counselor, there being such motion.
No, Judge.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Should be contained in exhibit 1 and attachments, Judge.
No objection.
State, you may be excused.
Thank you.
Did you review the admonishments with your attorney? Did you understand it and sign it in both places? I'm sorry, in all the appropriate places.
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that, yes or no?
Yes, yes, I did understand.
All right, did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, I did understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding to sentence?
Yes, Judge.
Anything you wish to say on behalf of your client?
We ask that the court follows the negotiated plea bargain agreement, Your Honor. He's been in custody pending this charge without the ability to bond out over the obvious immigration holds. And we're just asking for quality.
All right, the court will find you guilty as previously stated, sentence you to 128 days in the Bear County Jail under 1244. Give you credit for any time served, and there's to be no illegal reentry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, yes.
And did you sign it?
Yes, I did sign it.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, sir. Thank you.
Thank you.
All right, who's here on Mario Tovar?
Thank you, Your Honor.
Oh, thank you.
Thank you.
Where's Mario Tovar?
Use it in the box, Judge.
Come down. Morning. So have you received all discovery?
Judge, I need to request a blood draw, the blood discovery from the state. I have received an offer.
Okay.
And also currently, Mr. Tovar is remanded without bond.
Mhm.
If he was, we'd like to see about the court setting one. I will file a motion or a writ if you would like.
All
me to.
right, just speak with Ms. Ferguson and we'll take the matter up. All right, Norma, set this for a plea deadline date. Does the state have the blood discovery in their possession?
I do not believe so. I will file the motion today.
We don't have a judge, we need a motion.
Okay,
Sorry.
all right, no problem. We'll set this, Norma, recall this for July 8th. And that will be your plea deadline date if you have all discovery.
Yes, sure. And as to the bond,
Oh, you'll need to have Ms. Ferguson set it on the docket. Christina Garza? All right, so on this case, where are we on discovery?
I believe discovery is complete, and I'm just standing in for Elizabeth Russell. I'm sorry, I lost my voice.
Okay.
We did get our initial offer from the state. We're gonna provide mitigation by the next setting, so we're asking for 30 days, Judge.
All right, just one second.
This case was just indicted in March.
All right. All right, Norma, put this for a plea deadline date on June 24th. All right, on June 24th, you need to let the court know whether or not you've reached an agreement. If you have not reached an agreement, your next setting will be a jury date. You understand?
Okay.
All right, thank you.
Thanks, Judge.
Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thanks.
You're welcome. All right, Darren Johnson. Counsel, I don't have your motion.
Judge, I'm gonna give you a copy of it.
All
I
right, thank you.
filed it real early yesterday. I sent a copy to the state.
All right, court is calling 2024 CR 2675. State versus Darren Johnson. Can I have parties announced?
I can Galloway from state.
Green Davidson for Darren Johnson.
All right, and are you Miss Johnson?
Yes, ma'am.
All right,
Darren Johnson.
I'm sorry, thank you. All right, the defense has filed a motion to dismiss for speedy trial. And they're alleging that the complainant is deceased and it would deny the right for confrontation.
Judge, so that is correct. The complainant is deceased. The state believes that they have additional evidence to prove the case beyond a reasonable doubt. That would put the jury in a position to reasonably conclude from the evidence that is to be presented.
All right, defense.
Your Honor, with the additional evidence I believe they have is a video which is highly ambiguous. I would like to have a hearing on that as far as admissibility, if that's going to come in, but the video is from an angle that doesn't think this as to what really happened. The police officers that showed up on the scene initially told my client she was the victim. They got after Mr. Clanton for jumping in front of this truck.
Okay.
Later that changed. And so I can't really cross-examine him as to certain motives, but I would like to have Darren Johnson sworn in so I could get some evidence on the record.
Is it evidence as far as her testimony from that?
It's evidence as far as why she is prejudiced because we can't talk to this guy who's now passed away through no fault of hers.
All right, so what I can tell you, counsel, I'll take the testimony from your client, but it appears to the court that your argument as far as the person not being available because they're deceased is not an argument that's going to result in a speedy trial, granting of speedy trial to dismiss the case, because it's for the court. And if I'm incorrect, just let me know, counsel. For the court, it's similar to if someone, if there's a video, it's grainy and nobody can see anything, right? And a person ends up dying. Does that mean that a murder case is not filed? They don't go forward with the murder because someone is deceased? Or let's say that there is a shooting, and I understand what your argument as far as it's not her fault that the person is deceased because the allegations that she's charged with did not result in the complainant's death. I understand what you're saying by that, but then based upon your argument, anyone who's charged with a felony or any type of offense, if something were to happen where the complainant were to have a heart attack and die unrelated to this, then all those cases should be dismissed.
Your Honor,
Mhm.
I understand your argument, and I searched through Lexis last night,
Mhm.
and I found many cases where they were not dismissed because the defense attorney did not put on argument. And
Oh, no, I'm fine with you putting on the argument. I'm just trying to
yes, Your Honor.
figure out
Your Honor,
your
there
position.
were two witnesses in this case, my client and the deceased.
Okay.
It is our contention that he was very angry at my client for various reasons. I can no longer talk to him about that anger issue. It's a neighbor war situation where they were going at it, both of them were going at it for years.
Okay, so is your sole argument for this speedy trial and you're wanting to dismiss is because the complainant is no longer available?
It's also because 15 months have passed.
All right.
And case law seems to say 8 months is the threshold, at least inquired.
Mhm.
And so there's been some time passed. I had this case, I understand this court has other cases going, jail cases and all that.
Mhm.
But we have been here when he was alive.
Mhm.
And we were here all day, and then another jail case went before us, and I understand that. I understand that, except that now I can no longer cross-examine Mr. Clanton as to his motives as to jumping in front of this truck because he is deceased.
All right, and so that the record is I'll hear from your witness, but so that the record is clear, this case was in this court on June 27th. And I think there were some issues with your client not knowing that the case was set. So your client didn't appear until 11:56 a.m.
Oh, no, that's incorrect.
No. Let me finish. So then we were called on July 1st. Your client did appear. And then it was recalled on July 29th. There was an offer tendered and a plea deadline date of August 26th. Then on August 22nd, you came in and presented a request for an expert. Then you were set for trial on August 26th for November 4th, and it was to be an impact court. And I think some other case went in impact court. That was at the time when the courts were given impact courts to send overflow. Then on September 16th, 2024, you all were here, and it had to do with a no contact order, and I allowed contact for civil proceedings because there was a civil issue going on as well. And then on November 4th, you were called for jury trial on December 2nd. The court was in jury trial on December 2nd with State versus Richard Casanova. And then you were brought back on January 24th. And there was an agreed reset, and it was rescheduled because there was snow. And so it was to come back on April 1st. On April 1st, I allowed the defendant to appear by Zoom. And counsel, you appeared. And then we were called back on April 2nd. And at that time, we were currently in a jury trial on State versus McIntyre. And so then this was recalled for today. So I'll hear your witness. If you can have your witness raise your hand. All right, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Karen Johnson.
All right, defense, you may proceed.
Thank you. Ms. Johnson, how long have you lived next to Mr. Clanton?
I purchased the house in the summer of 2019.
Okay. And during that time, is it fair to say that there's been trouble between you two?
We're in a civil issue and they wanted me to move. So yes, there was problems.
Okay. And did Mr. Clanton, as far as you know, have any reason to have put empty trash cans out to prevent you from parking in front of your house?
He didn't want me to
Well, I'm
park.
not object to speculation. How could she know why the victim was putting, she can't testify.
He actually told me.
All right,
Park
so
there.
here's the thing. I will hear your evidence, but counsel, this is strictly for the court to make a decision on whether, on your motion for speedy trial and whether or not to dismiss because a witness is unavailable. All right, you may proceed.
Is that sustained or overruled?
Oh, it's overruled. You can ask the question and she can answer it.
You can answer the question.
Mr. Clanton asked me not to park in front of my house. It is street parking. The reason I wanted to park there is I had other cars in my driveway. My cars have been damaged. My house has had things thrown at it. My animals have been killed and I wanted to have visibility of my truck. I'm a corner house and if the streets are very narrow, so if I had a 350 truck, if I had it parked there and there was somebody parking on the opposite side of the street, it was very narrow.
Okay,
And
so counsel, with regards to this testimony, this is not related to the speedy trial issue that you have. So
Am I?
Can I redirect?
yes,
Specifically,
Yes.
would he have reason to be angry at you that you know of?
Yes, we're in a civil suit. It has to do with damage to my foundation from their Arizona ash tree roots, and it's cost them a lot of money.
Okay.
He was very angry at me.
So, you know, I pass the witness with respect to this issue.
I don't have any questions.
all right, anything else?
You know, I just reiterate that I asked this case to be dismissed because I cannot cross-examine this man as to his motives. I understand that murder cases, the person who allegedly murdered that person has some wrongdoing and now, you know, everything's allowed in. This is not a murder case. The DA could have indicted it as a murder case. They still can if they want to. This is a case where the complaint is gone. Yes, there's a video. That's our argument.
Judge, I'm just gonna restrict my argument to the speedy trial that's contained within the motion. And so there's this assertion that the length of the delay has been 15 months. I would submit to the court that it's been around 13 months. The defendant was indicted on February 26th of 2024, but not magistrated on the post-indictment fugitive warrant until April 7th of 2024. I would submit to the court that that's the day that the clock is running because that's the day that the defendant became aware of the charges pending against her. Regarding the reason for delay, I would bring or ask the court to take judicial notice of the court's file. There are two defense motions for continuance that were filed with the court on July 25th of 2024 and November 4th of 2024. In addition to some of the days, well, most of the days that this case was set for trial, the court was in trial. December 2nd of 2024, the court was in trial on a jail case. January 21st of 2025, the court was in trial on a jail case, and April 1st, 2025, the court was in trial on a jail case. There were additional motions followed by the defense, motions for investigator or motion for approval of expert witness funds filed on August 14th of 2024. And then there was another one that was filed. And so the state would purport that those are reasons for delay that should be held against the defense. That indicates to me that they weren't ready for trial because discovery wasn't complete on their end on things that they needed to do for their defense. Additionally, there have been a number of incidents involving the complainant and the defendant, which added to more discovery that we had to turn over to them. And so for these reasons, the state has never announced not ready. We are ready for trial today, and we're asking that you deny that motion.
All right. Any rebuttal or no?
Your Honor, the motions for continuances would fall because we were on what I thought was a trial docket, but these motions were never ruled on. You've been here, we've been asked to be here. All of the constitutional arguments that I iterated are in my motion. And for those reasons, I just don't believe she can get a fair trial because I can't confront the witness against her.
All right, defense's motion is denied. Thank you. Thank you.
Judge, I guess just with the motion and Lindy, I have had a chance to review it, and I will approach the court if I intend to get into any extraneous offenses. There is one thing that Mr. Davidson, that I'm not exactly in agreement with, so I don't know if you want to. For the code does specifically identify victims of assault as victims. And so I will let the court rule on that.
I'll allow you to defer to the complainant as the complainant. For the court, in criminal cases, it's not established that the person is a victim until it's established that they're a victim.
Okay.
So you may refer to the complainant by their given name or either as complainant.
Okay, and then all the other things I'll approach it. I intend to.
All right, and if you would let your witnesses know to refer to the complainant as a complainant or by their given name.
Yes.
All right, thank you.
You know, just one thing.
Yes.
Sorry to bring this up.
No, no.
When you said complaint, you mean defendant?
No, I mean the complainant.
I'm sorry.
Because you're saying that you don't want the person, the complainant in the case referred to as a victim.
Well, I actually said. Understand.
All right, okay, thank you.
Got confused, sorry.
No problem. Felipe Reyes, where are you all? Hello,
How you doing today?
I'm doing great. So when were you hired on this case?
Friday, yeah.
So that's Friday the 9th?
I believe so, Judge.
May 9th?
I believe that's what, oh, sorry, not the 9th. 16th, Judge.
All right, so here's the thing. I don't allow people to do this thing where they wait till the last minute to hire an attorney so they can get a continuance and their attorney is entitled to 10 days. Do you understand? So I'm giving him exactly 10 days. So you're coming back on the 27th and you're going to jury trial. My understanding, state, is this offer still on the table or no? All right, so today is your plea deadline date. So either you all reach an agreement or you have not reached an agreement. If you're not reaching an agreement today, then the court will not consider any plea bargain agreements without good cause. Otherwise, you're gonna have to plead open to the court. So you're coming back for jury trial on May 27th.
Thank you, Judge.
Anything else?
Nothing from the defense, Your Honor.
All right, Ms. Ferguson, they're on the docket for jury trial, May 27th, and they're number 1.
Yes, ma'am.
Thank you.
Thank you, Judge.
Thank you, Judge.
You're welcome. Who's here on Ramon, Ernest Ramon? All right, if you come forward. Ramon. Are y'all ready to proceed on the motion to revoke?
Yes, ma'am.
All right, court is calling 2023 CR 4166 State versus Ernest Ramon. Can I have parties announced for the record?
Ashley Jones for the state.
Michael Dwight going to the defense, Your Honor.
And are you Ernest Ramon?
Yes, Your Honor.
All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Ernest Lopez Ramon Jr. who was placed on community supervision in 2023 CR 4166 for the offense of assault bodily injury, married on January 17, 2024 for a period of 2 years? Is that you?
Yes. Yeah.
All right, state.
Yes, Your Honor, we are going to proceed on violation of condition number 24 on or about the 8th day of May 2024 in Bexar County, Texas, for defendant Ernest Lopez Ramon Jr.
did then and there fail to attend TAP assessment appointment as directed by the head of or authorized personnel of that agency in violation of condition number 24.
How do you plead to that? True or not true?
True.
State.
We will waive the remaining violations, Your Honor.
No objections, Your Honor.
All right, did you understand by pleading true to violation of condition number 24, the court could find it true, grant the motion, sentence you to 1 year in the Bexar County Jail?
Yes,
Knowing that you still wish to plead true to violation of condition number 24.
yes.
All right, is there, the court will find violation of condition 24 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That agreement is for 9 months in the Bexar County Jail. This was reduced from a third-degree felony to a misdemeanor.
That's correct, Your Honor.
All right, why, what has he done on probation?
Nothing, Your Honor. Let me. Yeah. He has not done the BIP. He didn't do the TAP. And trying to find the fees. Well, it looks like he may have paid a little bit, but is still outstanding in the fees.
All right, why didn't you do anything? You want to raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Ernest Ramon.
Yes. Why didn't you do anything on probation?
At the time, I just, I had an addiction problem. I got that, that was the main thing. I have an addiction last year to methamphetamines, and this year, that's when I went out and reached for help. I completed a program for San Antonio Recovery Center. I was there for a whole month. But that's the main reason. I'm homeless. I just lost I lost my mom in COVID. I lost my mom and my sister to COVID. So I was dealing with my depression and some mental issues. Trying to get help for that. That's all I can really say.
All right. All right, the court is finding violation of condition number 24 true. The court will sentence you to 1 year in the Bexar County Jail, give you credit for any time served. There's an affirmative finding of family violence and there's to be no contact with the complainant. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right. This is not a plea bargain agreement. You have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you're on a community supervision. You understand?
Sure.
And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sure.
All right, we can go off the record. When you're released from custody, if you can't find a place to go to help you with your addictions, if I'm still here, come back here and I will pick up the phone, call a place to help you, okay? All right, good luck to you, sir.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome. Who's here on Jose Caceres?
I am.
Are you all ready to proceed on the motion? All right, the court is calling 2022 CR 0057 State versus Jose Caceres. Can I have parties announced?
So,
Ashley Jones for the state.
Branch party for the defendant.
And are you Mr. Caceres?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yeah.
Are you the same Jose Angel Caceres Jr. who was placed on community supervision in 2022 CR 0057 for the offense of injury to the elderly bodily injury on March 28, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
State will proceed on violation of condition number four in Bexar County, Texas. The defendant Jose Angel Caceres Jr. did then and there fail to report to the supervision officer as directed for the months of November and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
It is true.
And the state will waive the remaining violations, Your Honor.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 6 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 4? It's the not reporting for November and December. Do you understand?
Yeah.
Well, do you understand that they're saying that you didn't report?
I didn't report because I got confused where was that and stuff. And that's-
No, no, no. My question is, you pled true to number 4.
Okay.
Do you understand that you pled true to number 4? All right, so in violation of condition number 4, they're saying that you didn't report for November 2024. Did you report for November 2024? Did you report for December 2024? All right, so because you're saying you didn't report for those days, I can send you to prison, and I can send you to prison up to 6 years. Do you understand that? All right, so do you still want to say that you didn't report for November and December?
I tried to report. But
No, no, no. You're giving me a reason for not reporting. Do you understand that I can send you to prison for not reporting? No, do you understand? You don't understand?
I'm sorry.
All right, so this is what I want you to do. Take a deep breath. Relax, take another deep breath. Relax. All right, so do you have an agreement with the state?
We do, Your Honor.
All right, so even though you have an agreement with the state, I don't have to follow that agreement. Do you understand? You need to speak up.
Okay.
No, it's either yes or no. Do you understand?
Yes, sir.
All right, so because you didn't report for November and December, I could send you to prison. Do you understand?
Yes, ma'am.
All right, so you still want to go forward knowing that I don't have to follow an agreement that you've reached. Do you still want to go forward? All right, then. I'm going to have you step back.
Thank you, Judge.
You're welcome. Richard Ibanez. Who's the attorney? Oh, hi.
Know that the court placed me today on Mr. Ibanez's matter.
Yes.
That's the other attorney unavailable. I've got his contact information. He has mine, just requesting a little bit of time to look into the discovery to confer with the state. I'm regarding.
All right, and was the state able to tender an offer or no?
No, Judge, I haven't been able to speak with them yet. I've had some other matters, but I was just requesting to look into the reports, the videos, and then that way I can have a meeting of the minds next time to see about a potential offer. I need to get my bearings as to the facts.
All right, Ms. Ferguson, I need a 30-day reset for discovery on Ibanez.
That'll work, yes.
All right, we'll see you back on June 17th.
After doing the reset form, my client be excused, Your Honor?
Yes.
We're gonna go inside reset form.
Hello. Counsel, are you ready?
I think so, Judge.
All right, have him come forward. All right, we're back on the record in 2022 CR 0057. So, Mr. Casares, did you have a chance to speak with your attorney? Do you understand by pleading true to violation of condition number 4, the court could find it true and send you to prison for up to 6 years? Did you understand?
Yeah.
I'm sorry, that's either yes or no. Yes? All right, the court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor. That proposed agreement is to follow the recommendation given by probation, which is to have the probationer complete the TCOOMMI/CHCS evaluation that is set for July 24th of 2025 in custody for possible DDRF placement followed by MIC.
That is our agreement, Judge.
All right, are you asking the court to follow that agreement?
ma'am.
Are you waiving your right to appeal?
Yes.
All right, the court will find violation of condition number 4 true. The court will deny the motion, alter and amend the conditions to include a Takami evaluation. And the defendant is to remain in custody until the evaluation is completed. Yes. All right, is there anything else you need from me, sir?
No. Thank you, Miss.
All right, you're welcome. So here's the thing, we can go off the record. you're gonna have to make sure, I understand there are mental health issues going on, but you're gonna have to make sure that you report to your probation officer. And if you're confused about if you have a date, let probation officer know. If they're not responding, you can come back to court, okay?
Cause I was looking for Haven Grove, but there was more than one place for the homeless and I got confused. There was like 4 different places and stuff like that.
Okay, all right, that's when you pick up the phone and you call your probation officer and let them know, okay?
Okay, so I tried to get that, and the free clinic, I couldn't find the free clinic either for medication and stuff like that.
Okay,
So yeah, everybody, I'll ask them, I'll ask around.
all righty. Good luck to you.
Thank you.
Thank you. Yes,
Judge Madison,
yes,
Mario Alberto Tovar.
yes.
On discovery order.
David Brown. And then after Brown, it will be Washington. Hello.
Good morning, yeah.
Good morning.
We're here on a motion to set bond.
All right, have you spoken with the state?
This one. Have the notes here. I'm asking of the bond to be reinstated. Mr. Brown missed his court date. My understanding due to mistake of not of his own.
Well, in order for the court to reinstate the bond, you'll have to call the bondsman and see if the bondsman wants to be back on his bond. Because was he on a commercial bond?
Yes.
All right, so if you want to call the bondsman and see if the bondsman wants to be back on his bond, the court will reconsider.
Because
when I told him about the court date,
it was their mistake, Your Honor.
All right, so if you call the bondsman and see if the bondsman wants to be back on his bond. All right, thank you. All right, so if he has a warrant, why, and has no bond, why is he? All right. Thank you. All right, Patrick Washington.
Mr. Washington, come on up. There's really a trial date as soon as possible.
All right, he was supposed to be set for trial for today.
Yeah, and that is a fact. And so we need to be, as soon as you have another opening.
All right, why isn't he dressed for trial though?
That's a great question. Everybody else came over dressed. I'm not sure. You have clothes over there, Mr. Washington?
Yes, I do. Is y'all ready for trial today? I'm ready.
Okay, this is what I'm going to do. I don't know about this trial that's coming up, whether or not it's going to finish soon or not, or, so what I will do is, I'm gonna have you recalled for tomorrow, and we'll have him brought over dressed. Now, Mr. Washington, if this trial actually goes, then I won't be able to try your case, okay?
Well, yeah, in any way possible. I'm willing to go with prosecutor deal, but I want to get out today instead of a month and a half that they want.
All right,
me
so
to do.
here's the thing, I don't like for people, I'm hoping people are not taking agreements just so they can be released from custody.
No, it ain't here. What I'm doing is trying to save the state a little time and state.
Oh, no, here's the thing, let me just tell you, don't ever try to save the state time to your detriment, don't do that.
Yes,
So what I can tell you is, I will have you brought over dressed for tomorrow. If you decide to enter an agreement with the state or something of that nature tomorrow, then I'll keep the plea deadline date open. Or if you want a bench trial, I'll do a bench trial.
Just listen to,
Yeah.
hear the judge out.
So here's the thing, with bench trials, what ends up happening is a jury doesn't hear the evidence. So it won't be 12 people. I would just hear the evidence. And I would make a decision on whether you're guilty or not guilty based upon the evidence that I hear. What I can tell you is, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. You understand?
Yes, ma'am.
So that'll be something for you to think about.
I want to stay on the jury's how.
Okay. All right. And so here's the other thing, Mr. Washington. Let me explain to you about things that happen at the Bexar County Jail. Sometimes we have people who refuse to come over. And so the deputies have a lot of people to bring over, so they don't bring them over. Then they come to me and they say that person refused. Then I sign an order saying, hey, no, they need to bring them over here. It's the same thing about people being dressed for trial. When I tell people you have a jury trial date and I tell the deputy, let them know that the inmates need to be dressed for trial. Well, if you tell a deputy over at the jail, I'm not dressing for trial, they're not going to talk to you and try to force you to put on clothes. The only way you'll have clothes if I send an order and say, hey, they need to be dressed for trial. So the reason why you're not dressed for trial today and everybody else is dressed for trial is because the people at the jail told me that you refuse to be dressed. So
Right, because what do it make a difference of whether you're innocent or guilty with clothes?
you know what? I would tell you this. I had a client once and he was a young client. And I told him, hey, look, I'm going to get you some clothes. I want you to be dressed nice. And he said, I'm not trying to impress anybody. And I told him it would be different if everybody on that jury were your friend and they knew you. Usually people who are on the jury, they don't know you. And it's like when you get a book. When you look at a book, sometimes you'll look at a book and you say, I don't want to read that book because I don't like the way the cover looks. So you want people to look at you, to be interested in seeing what's going on with you. If you come over from the jail dressed in that uniform with those flip-flops and with handcuffs, a jury, hopefully they will be nice and they will say, you know what, we're going to listen to the evidence. But maybe in the back of their mind, they may be saying, yeah, he did something wrong because look at him. He's dressed in a uniform from the jail. So they're going to know you're in custody. And they're going to say, look at him in chains. He's dressed in chains. So that means maybe he's dangerous and we should be afraid. And they may not even listen to the facts. Do you understand? So when you're asked to be brought over dressed for trial, that's to help you out, okay? So don't tell the deputies you don't want to be dressed. Now, see, then your attorney was thinking, why are you not dressed for trial? And you didn't let your attorney know the reason why you're not dressed is because you refused it.
Well, I don't see it that way. I see it in a way of if you're innocent or guilty, that's what the court should base everything on.
I mean, that's
Not
true.
the clothes you wear.
But let me just tell you this, you know what the problem is? They're not going to be attorney, who knows, maybe there'll be an attorney on your jury, but there's not going to be any defense attorney. So it's just going to be regular people. And you know what? Usually it's regular people who have never been in trouble and they don't understand about people being in trouble. So you're going to have to make sure that when they ask you to get dressed, that you're dressed, okay?
Yes, ma'am.
Will you do that for me?
Yes, ma'am.
All right. And then the other thing, if you'll talk to your attorney and make a decision, if you want a jury trial or a bench trial. Okay.
You just said we're talking a little bit more.
All right. So your attorney is here. So you all need to talk about that today, okay?
Is he coming back tomorrow?
He's coming back tomorrow. Yes.
Okay.
Okay. All right. Thank you.
Thank you, Judge.
You're welcome. Christopher Guerrero. Oh, good morning. So where are we on discovery?
Judge, we've executed a discovery acknowledgement already. We just need a plea deadline date.
All right. And you received an
I didn't see it
offer?
on the docket, Judge.
Yeah, that's why I'm looking.
He didn't print out on the docket, Judge. That's what
Okay.
Norma tells me.
All right, so and thanks for showing up. You know, anybody, well, some people would say like, my name not have been called, let me tip out of here. So I appreciate you not tipping out. All right, so what we're gonna do is, counsel, are you available June 24th?
I believe so, Judge. Let me just check. Yes, I'm available, Judge.
All right, so your plea deadline date is gonna be June 24th. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not, your next court date is going to be a jury trial setting. All right, thank you. Who is here on Claudel Corney? All right, are y'all ready on this motion to revoke?
We are, Your Honor. We need a contested hearing.
All right. How much time do y'all need for the contested?
Whatever you say.
All right, Ms. Ferguson, I need a 2-week reset for a contested hearing. All right, we'll come back on June 2nd And that will be a contested hearing. Oh, good morning. All right. Yes.
I just wanted to say for the record that I've been doing good on probation.
Okay, let me just tell you, that's something that you'll need to address at the contested hearing, okay? And then your attorney can present whatever evidence he wants me to hear and I'll hear it, all right?
Just before.
All right,
June second.
yes. That'll be in 2 weeks, okay?
Yes, ma'am. Thank you.
You're welcome. All right, Ross, they're trying to get your client to come over, so you'll need to come back in the afternoon.
Yes, Judge, I was informed that she refused to come again, so.
Yeah, so we've ordered her to come over, so they'll be bringing her over.
Yes, Your Honor.
Okay,
So 1:30, Your Honor?
yes.
Thank you, Your Honor.
All right, thank
Excuse,
you.
Judge?
Yes,
Thank you.
thank you for your patience.
Yes, Your Honor.
Xavier Slingerland? All right, so on this case, where are we on discovery?
Discovery seems to be intact. We don't have discovery concerns regarding this case at this time, Judge. We were extended an offer by the state today. My client wants a little bit of time to think about it. We're requesting it be set for a plea bargain deadline, please.
All right, how old are you, sir?
34.
All right. Counsel, are you available May 22nd,
22nd.
Thursday?
This Thursday.
Mhm.
We're hoping for a little bit more time.
29th?
We do a couple weeks, 2 weeks, the 29th. Is the first week of June available by chance?
All right, I can set you for June 5th.
Yes, Your Honor, that'd be perfect.
All right, Norma, on this case, plea deadline date, June 5th. All right, thank you.
Thank you, Your Honor.
Adolph Mendoza. All right, so where are we on the discovery?
Discovery looks good, Judge. We did receive an offer today from the states. And my client, again, needs some time to process, think about it. So however the court would like to proceed in terms of the time we're allowed to do that. And I guess if he's not ultimately wanting to accept, we would be requesting a trial, but
All right, June 5th would be your plea deadline date.
thank you, Your Honor. Upon doing the reset, maybe he be excused.
Yes, thank you.